Hello. In this clip from our Justia webinar, Confronting Racial Bias in Jury Selection, Angie Setzer reviews how minorities are excluded from jury selection and how it affects the fairness of the legal system. If you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
So, despite the importance of representative juries, most jurisdictions have not adopted readily available and accessible procedures necessary to achieve full representation. As a result, Black people and people of color continue to be excluded at every step of the jury selection process. When the court creates the system, the lists of potential jurors, when potential jurors are notified to come to court, when judges decide which potential jurors are qualified to serve, and when prosecutors use challenges for cause and peremptory strikes to remove the potential jurors. So let's talk about the exclusion of people of color in jury pools, this first step, okay? The Constitution requires that the juries in an individual case be chosen from a fair cross-section of the community. But Black people and people of color are often underrepresented because the source lists underrepresent people of color. We know that federal courts, pursuant to the Jury Service and Selection Act, federal courts rely primarily on voter registration records as a source for jury lists. Many state courts also use voter registration records as the primary source of jury lists as well. But recent changes to voter registration laws and a variety of socioeconomic, geographic, historical reasons mean that many racial and ethnic groups are not fully represented on voter lists. So if the voter lists are the primary source, it then means that the jury lists are not representative of the community. Some states use driver's license or state ID lists as well. Those lists also tend to disproportionately exclude people of color. And obviously this is a problem because if the initial master list is not representative, then it's less likely that the final jury will represent the community. After the jury list is compiled, summons go out to individuals who are going to serve on the jury. And this is another point in the process that can create racial disparities. Nationally, about 12% of juror summons are returned as undeliverable. This may be because the court fails to check addresses regularly against a change of address database. It may be because the master jury lists are not regularly updated. Again, this is an area where racial disparities can be created. People with low income levels who are more likely to move frequently have a higher rate of undeliverable summons than middle or high income people. And because Black people and people of color in our country are disproportionately burdened by poverty, they are more likely to be excluded at this point because of this practice. So while these practices have led to significant underrepresentation of people of color in the master jury list, sort of in the initial list, it's very difficult for individuals to succeed in challenging these jury pools as unrepresentative. I'm sure some of you are familiar with what's required to make out a fair cross-section challenge under the Sixth Amendment. The Sixth Amendment fair cross-section entitles a defendant to a trial by an impartial jury that is drawn from sources reflecting a fair cross-section of the community. And there are really three requirements. First is that the underrepresented group is cognizable. Second is that the underrepresentation is significant and not fair or reasonable. And this is where most claims fail, because most courts have used this absolute disparity test for measuring whether the underrepresentation is significant. And absolute disparity test is really just subtraction, right? It's the difference between the percentage of a particular group in the community and the percentage of that group in the jury pool. Typically, courts have required that percentage be greater than 10%. The problem with absolute disparity is that it doesn't actually capture or measure the decreased chance that a defendant will draw a representative jury because it doesn't take into account a group's size. So as an example, if one group is 75% of the population and 70% of the jury pool, that's an absolute disparity of 5%. Another group can be 10% of the population and 5% of the jury pool, and the absolute disparity, again, is 5%. But the chance that a representative of a group will be impaneled on a jury decline by half in the 10 minus 5 scenario. and only about 7% in the 75% scenario. In 2010, in Borghese v. Smith, the Supreme Court recognized that absolute disparity can be misleading, particularly where a group is a small percentage of the population. And, you can imagine a situation in which there's no legal challenge where that group's population is less than 10%. But states, have continued, or courts have continued to use this test in determining underrepresentation. The third requirement is that the cause of the underrepresentation is a systematic practice. And again, this is a point at which many claims fail, largely because courts are unwilling to find things like, source lists or failing to keep addresses up to date as systematic practice. It is true that at this point, there's no requirement of intent. So unlike a 14th Amendment challenge, there's no requirement that the actors are intending to exclude people, but it is still a point at which courts have not really recognized these other factors as systematic practices. So I want to now move on to the sort of next phase of jury selection. After you sort of have the master jury list, after people are summoned to come to court, the jurors arrive and they are qualified. Legal qualifications for service usually include age, that you're a citizen of the county, that you're a resident, that you're proficient in English, or that you don't have criminal convictions. Again, these are points where disparities can occur. For example, English proficiency. Federal courts and most state courts require that you be proficient in English, but 87% of people with limited English proficiency in the United States are people of color. So in jurisdictions with large number of citizens who are not proficient in English, these restrictions produce juries that are actually not representative. Likewise, with criminal convictions, I'm sure many of you are familiar with the fact that being charged with or convicted of a felony can exclude you from jury service in many states. But it's also true that in some states, a misdemeanor conviction can result in lifetime exclusion from jury service. And a couple of states, actually just being charged with a misdemeanor can exclude you from jury service. So these are ways in which additional sort of underrepresentation occurs. Another way that people are sort of removed from the jury at this point is for undue hardship. And this is primarily financial, right? Undue hardships tend to deny people with low incomes the opportunity to serve on juries and further decrease the chance of a representative jury. And we can see this in a couple of ways. Payment, right? All states prohibit employers from retaliating against individuals who are serving on juries. But most states do not compensate individuals for serving on juries. And even in states with generous compensation, for individuals who work multiple jobs or who are self-employed, there is no there's no compensation for lost wages. There's only about one state, and juror pay has not kept up with rising cost of living or inflation. There's actually only one state, which is New Mexico, that ties juror compensation to a minimum wage. But again, this is sort of an area where people with, sort of a lower economic income are going to be prohibited from serving. And individuals with childcare needs, individuals who have transportation needs, all of these things limit an individual's ability to serve on a jury and then limit the representativeness of the jury pool by decreasing the individual's ability to participate. Once a juror has been qualified, then individuals can be challenged for cause. That is a cause challenges to a juror who cannot be fair and impartial. But studies have shown that there is a stark racial disparity in the way that challenges for cause are used by prosecutors. A recent study of 12 capital jury trials in Duval County, Florida, from 2010 to 2018, showed that Black jurors and jurors of color were excluded for cause at rates more than twice that of white jurors. In a North Carolina study involving 1,300 trials and 30,000 jurors, it was found that trial judges were 30% more likely to remove prospective jurors of color than white prospective jurors. We see this in studies in Louisiana and Mississippi as well, and those are all documented in our report. And I just want to sort of highlight that in cases where courts have eventually found a Batson violation. That is, the court found that the prosecutor peremptorily removed jurors on the basis of race. There's often a corresponding use of challenges for cause to remove Black jurors and jurors for color. We can look at Flowers v. Mississippi. This was the case I cited to earlier, Justice Kavanaugh's quote. In that case, Mr. Flowers, Curtis Flowers, spent 24 years in prison, and he was tried 6 times in Mississippi. In those 6 trials, the prosecutor removed 41 of 42 qualified Black prospective jurors, and eventually in 2019, the United States Supreme Court found that there was a Batson violation. And so the court's opinion really focuses on the peremptory challenges. But it's important to note that in that case, the prosecutor used challenges for cause to actually remove a significant number of Black jurors. In that case, in the case that was before the court, the final pool of qualified jurors was relatively balanced. It was 88 white jurors and 68 Black jurors. By the end of the cause process, the challenge process, 100 jurors were removed for cause, and there were only 10 Black jurors remaining. So that was 58 Black jurors had been removed for cause. Likewise, in other cases, this has happened in Wells. But challenges for cause are largely unregulated. And as a result, individuals are removed for cause based on things like being victimized by racial bias, experiencing race discrimination, having concerns about the reliability of the criminal legal system. The perspective of African Americans in this country is critical, especially given our history of racial bigotry, and really shouldn't form a credible basis for exclusion. All right, so I talked a little bit about peremptory strikes, but after the jurors have been qualified and remain after challenges for cause, the final step is to narrow down the pool through the use of peremptory strikes. This is a point at which, jurors can be removed for any reason at all. In 1965, in Swain v. Alabama, the United States Supreme Court said that you cannot intentionally remove people based on race. In that case, all 6 Black jurors had been removed. But the Supreme Court also said that it wasn't enough to just show the prosecutor's conduct in an individual trial. You had to show the prosecutor's conduct over the course of several trials. And this burden proved too high for Mr. Swain in that case, and actually for most defendants. So in 1986, in Batson v. Kentucky, the court revisited this issue and allowed an individual to show intentional discrimination in an individual case and established a sort of 3-step legal standard. First, the defendant has to make out a prima facie case, demonstrating that the facts and circumstances raise an inference of discrimination. Now, this is a really low bar, and the court has made that clear. If a prima facie case is met, then the prosecutor is then required to provide a race-neutral explanation for the strike. Again, this is a very, very low bar. The Supreme Court has made very clear that essentially it can be any reason at all. It doesn't have to be plausible. It doesn't have to be probable. It just cannot be race-based on its face. It has to be race-neutral. And after those 2 steps are met, the 3rd step is that the trial court must then decide whether the defendant has established purposeful discrimination based on the totality of the circumstances. In his Batson concurrence, Supreme Court Justice Thurgood Marshall expressed concern that this 3-step process would actually not eliminate racial bias in peremptory strikes. And in the 35 years since Batson, its inadequacy in addressing and eradicating racial bias in jury selection has become fairly apparent. We see that prosecutors continue to use peremptory strikes in a racially discriminatory manner. We see that courts remain largely indifferent to racial bias in jury selection. Defense lawyers are often ill-equipped or unwilling to challenge racial bias. And excluded jurors actually themselves have no remedy for challenging discrimination. So I just want to talk a little bit about each of these things. First, numerous studies document the extent to which prosecutors continue to use peremptory strikes in a racially discriminatory manner. In Mississippi, we have a study of a 25-year period ending in 2017, which found that Black prospective jurors were 4 times more likely to be struck by prosecutors than white jurors. A Louisiana study analyzing 5,000 cases from 2011 to 2017 found that prosecutors struck Black jurors at 175% of the expected rate based on the proportion of the jury pool. And then this more recent study and report out of California showed a study of 700 criminal cases decided by the state appellate courts through 2018 that prosecutors used strikes to remove Black jurors in nearly 72% of cases, while using peremptory strikes to remove white jurors in fewer than 1% of cases. So I just want to spend a little time looking at how prosecutors, judges, and defense lawyers remain largely indifferent to the need for representative juries. So let's start with prosecutors. Prosecutors are elected officials. They're elected from the community they serve, and they're obligated to follow the law. But it often seems that Batson did not deter discrimination so much as incentivize ways around discrimination. After Batson, many prosecutors' offices responded by having trainings, producing cheat sheets for prosecutors, a list of reasons that would have been deemed acceptable by the court. But prosecutors continue to use insulting pretextual reasons intended to conceal racial bias. And we see this in cases all the time. One example is the use of, quote, low intelligence. It's a negative stereotype that has been used throughout our history to exclude African Americans from voting, from jury service, but is still asserted as a basis for a strike. And we have cases like McGahee v. Allen, which is an 11th Circuit case where the 11th Circuit found a Batson violation, where a prosecutor had asserted that 6 of the 23 African American jurors were of low intelligence, and that was the basis for striking them, even though the prosecutor did not ask a single question and had no information about the jurors' education, grades, IQ scores, degrees, any of that. Another example of this sort of pretextual reason would be living in a high crime area or a bad zip code, which is often food for a predominantly Black neighborhood. Or things like, I couldn't form a rapport, or the person wouldn't look me in the eye, or the juror didn't laugh at my jokes. And these are sort of entirely subjective reasons that fail to account for implicit bias of the prosecutor and continue to be used. In fact, prosecutors often put forth reasons that are based on troubling racial stereotypes. This study in California showed that prosecutors rely on racial stereotypes about demeanor to justify strikes in about 40% of the cases. And it's not something that just happened in the past. I mean, we have cases in the 2000s, in the 2010s, 2012, 2015, where prosecutors are using these sort of troubling stereotypes. A New York case, a prosecutor in 2012 said that a Black woman was struck because she was too, quote, outspoken. In a Louisiana case, a Black juror was struck because the prosecutor said he, quote, looked like a drug dealer. So these are these are things that continue to be used in criminal legal cases. But why? Why do prosecutors continue to engage in this conduct? I think one big reason is that there is no accountability. There's no consequence for a prosecutor who violates the constitutional rights of the defendant or the juror in removing them based on race. Nothing happens to a prosecutor if she is found to have engaged in discriminatory conduct. There's no disciplinary action. There's no anything. In fact, recent studies have failed to find a single case where a prosecutor was subject to any sort of barred discipline as a result of being found to have violated Batson v. Kentucky. And prosecutors, in fact, regularly get reelected. Doug Evans was the prosecutor in the Curtis Flowers case, and he was reelected to an 8th term after having been found to violate Batson. So in connection with this, I want to just return quickly to the Civil Rights Act of 1875. This act actually survived the Supreme Court's gutting of a lot of the civil rights acts that were passed during Reconstruction, and is now codified at 28 U.S.C. Section 243, which, the law basically makes it a federal crime to exclude any citizen from a jury on the basis of race. It imposes a fine of $5,000 in 1875, which is the equivalent of about $100,000 today. It was upheld in Ex parte Virginia, this 1879 case, but not a single person has ever been convicted under the statute. And as I'll discuss in a minute, attempts by the excluded jurors to use this statute to hold prosecutors accountable through a 1983 action have actually been fairly unsuccessful. I'm going to get to that just momentarily, but I want to talk first about courts and the courts being largely indifferent to what's going on here. We know that courts are under an affirmative duty to enforce the prohibition against racial discrimination in jury selection. But when we surveyed state appellate courts opinions across the country, we found that courts are refusing to enforce Batson. We looked at state appellate courts. In our report, we revealed that the highest state court in 32 states, courts that have considered hundreds of illegal discrimination during jury selection claims, not one has found that a prosecutor violated Batson. Example would be a 2014 Mississippi Supreme Court case where the court acknowledged that the prosecutor struck Black jurors at more than twice the rate at which the prosecutor was, at more than twice the rate at which they appeared in the pool, but refused to find discrimination. This is true even where the courts are finding that prosecutors are treating Black and white jurors differently. And in fact, appellate courts in several states have reversed findings of lower courts that a Batson violation occurred. At the same time, many of these state courts are expressing a hypervigilance around policing what we call reverse Batson claims, which is where a defense lawyer is accused of illegally removing white jurors. And I just want to give an example. These are also in our report, Mississippi. So in 95% of the cases in which the Mississippi Supreme Court considered challenges to the removal of Black jurors, the court found no Batson violation to occur. In contrast, since Batson was decided, that same court has reviewed 13 reverse Batson challenges and found a Batson violation in 11 of them. Courts not only sort of are remaining indifferent to the facts and the evidence before them, but they're also creating procedural barriers or procedural bars to prevent even considering claims of racial bias. Some appellate courts refuse to address claims of racially discriminatory jury selection if there's no objection made at trial contemporaneously. Some courts require that multiple objections be made in order to preserve the claim. And so if a state court refuses to review the claim, then of course a federal court is largely prohibited from doing so as well under the Anti-Terrorism and Effective Death Penalty Act, which prescribes the ability of federal courts to review claims that have been sort of barred from review by the state courts. As a result, we've seen individuals who've been executed even though they have significant claims of racial bias during jury selection. And I just want to highlight one of those individuals, Robert Tarver. He's a Black man who was executed by the state of Alabama. He was sentenced to death in Russell County, Alabama, really despite significant evidence that his co-defendant was the one responsible for the shooting. But he was tried in Russell County, Alabama, which at the time was about 40% African-American. He was tried by a jury of 11 white people and one Black juror. Later, the assistant DA admitted to removing people on the basis of race, but the state court and the trial court said there was a Batson violation, but that there was no relief because it had not been, defense lawyer didn't properly object at trial. And then, of course, the federal court said, well, we can't review that claim because it was not properly raised in state court. And Mr. Tarver was eventually executed in the electric chair, actually. So I just want to briefly touch on defense lawyers because that's sort of the final piece there, right? We have the courts, we have the prosecutors, but we also have defense lawyers who, under the Batson framework, are largely responsible for policing racially biased strikes. But defense lawyers in a majority of the criminal cases are largely underfunded, overworked, without resources or training to effectively raise and prove a claim of discrimination. They're often prevented from access to jury information. Many state and federal, or many state courts certainly do not require that administrators keep jury information. So this is something that defense lawyers actually aren't able to get access to. Some states have laws preventing them from getting access or make it very difficult for them to get access to this information, which would allow them to challenge either the underrepresentation of the pool or other practices that are preventing their client from getting a representative jury. And defense lawyers are mostly white, which makes them less likely to identify and challenge racial bias in the courtroom. At the end of the day, it's not just the criminal legal system has been undermined, the trial is unreliable, but it's also that jurors are being excluded based on race. It violates the juror's right not to be excluded. And the Supreme Court has recognized that jurors, in fact, may be the most aggrieved, but jurors often have no remedy for challenging race discrimination. Prosecutors have absolute immunity for lawsuits seeking money damages over past actions during trial, including race discrimination. Courts have denied jurors the right to sue to prevent race discrimination in jury selection. And I mentioned this earlier, the Civil Rights Act of 1875. In Alabama and in Mississippi, groups of jurors who lived in the community sued to prevent the prosecutor from intentionally discriminating against them in future cases. In Alabama, the federal court dismissed the case, and the appellate court, the 11th Circuit, found that while it didn't disagree with the facts, there was no, it accepted the facts as true, that under the abstention doctrine, the federal court could not intervene in state court proceedings. This lawsuit was also filed in the county in which Doug Evans was a prosecutor in Mississippi, and the court there likewise held that the suit was not right, basically that the jurors did not have standing to sue because they had failed to show a sufficient threat of constitutional injury. The dissent in that case, I want to note, pointed out that abandoning this type of civil rights suit that historically has allowed excluded jurors to participate in our justice system impairs the jury right itself.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please hit the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.